All right, everyone, I think we are about ready to get started. I am outside and there is some leaf blower noise going on. So someone, including you, Kwaku, should please speak up if that becomes a problem and I can try to move. But hopefully by using the headset, that'll make things work. Can you hear me, Kwaku?
I can, and let me say hi to everyone and issue my own, COVID setting apology in advance. I have a 6-month-old who may peep in from time to time. You might hear her through the wall. Hopefully not, but if she does, if you do, she says hi, and she's a strong supporter of legal aid.
Fantastic. I hope she does put in an appearance. So thank you all for joining us this afternoon. I am Jonathan Levy. I'm with the Legal Aid Society of the District of Columbia. I'll give you a little more of an introduction shortly. And you can also see Kwaku Okoa, who is a partner at Sidley Austin. And we are going to be hosting a discussion with you that I hope will be more of a discussion and less of a lecture on poverty law in the DC appellate courts. So the caveat that I want to start out with is that this will be much better for both Kwaku and me, and I believe for all of you, if you guys ask questions about this topic that will guide our discussion. You can ask the questions in the chat function, and Caroline will break in with those questions at appropriate times, and we will do our best to answer them. We are both appellate lawyers. We are not lecturers, although Kwaku may be a lecturer also because he's more of a Renaissance man than I am. But we are used to talking for about 20 seconds at a time before being interrupted with a question. We're much more comfortable that way. So please ask your questions, and we hope to guide the conversation in a way that will be the most interesting and profitable and beneficial for all of you, and it'll also definitely make it more interesting for us if you do it that way. So please, please, please ask questions and ask them often and loudly. So again, to introduce myself, I'm Jonathan Levy. I'm the Appellate Director at the Legal Aid Society of the District of Columbia. Most of you, I think, already know Legal Aid. We are the oldest and largest general civil legal services organization in the District of Columbia. I'm going to give you more information about Legal Aid in a moment than you want to hear. And I am the director of the Barbara McDowell Appellate Advocacy Project at Legal Aid, which is essentially Legal Aid's appellate arm. And I will also give you more information about that than you ever wanted to hear shortly. I want to start out by thanking Kwaku, who I will ask to introduce himself in more detail shortly, and also the wonderful folks at Legal Aid's Development Department, including Rob and Caroline, who made both this particular webinar and this whole series of webinars happen. And Caroline in particular is on the line with us now, and she's going to guide this conversation and move us through the slides and look at and break in with your questions and really help us out that way. So thank you, Caroline. And now, Kwaku, if you don't mind introducing yourself, that'd be awesome.
Absolutely. Hi, everyone. I'm Kwaku Okoa. I'm a partner in the Supreme Court and Appellate Practice at Sidley Austin. I'm also a member of the Board of Trustees of the Legal Aid Society of DC, and I've recently joined the executive committee of that board. As the name of my group suggests, I'm also an appellate practitioner. Would very much like to get your questions as our discussion proceeds, and if we do proceed as a discussion, it will be a lot more fun, or at least you'll get to see Jonathan and I on our toes, which is where we like to be.
Great. So we can move on to the next slide, so we don't have to look at us for too much longer. There we go. So this is again just meant to guide our discussion, and I really hope that you will modify this agenda on the fly. But what we hope to talk about today includes giving you some information about legal aid in particular, and also the broader legal services community in the District of Columbia, which we are really fortunate to have a robust legal services community here. I think the most robust in the country, to be honest. And then we're going to pair that with the second topic, which are the 2 points of this webinar today, which is appellate representation, and particularly appellate representation of low-income DC residents, and talking a lot about the various different ways that different types of attorneys provide appellate representation to low-income DC residents, because all of you can do this. Any DC attorney can do it, and many do, from a variety of positions, whether it's from working directly with legal services, whether it's working in a governmental capacity, whether it's working in a law firm or a corporation, or any sort of attorney capacity. And I want to talk about all of those sort of different ways. Then the third item that we will discuss is something that most of you already know something about, which is the stages and aspects of appellate representation. But I want to look at those through a lens, particularly of pro bono representation. And part of this is thinking broadly about who can and should be involved in appellate representation of low-income folks. Because by looking at the different stages of representation, I think what you'll see is that there are different lawyers, and even to some extent non-litigators, who can get involved in different aspects and at different stages of appellate representation. And then either at the end or more likely throughout this conversation, we're going to talk about the BEMA case, which is just one example of a collaboration between legal services and law firm lawyers. And it's the example we're going to use because it's largely a collaboration between myself and Kwaku. And so we actually know a little bit about it and can use it as a bit of a case example.
Jonathan, let me just add on BEMA that it was not just me and Jonathan, but on the Sidley side, our associates and summer associates playing a key role in developing the arguments and writing the brief, and then also a fellow at Legal Aid, who was actually 2 of them, one in the briefing stage and one in the argument stage, who are very closely involved. So the role for a lot of people, including summer associates and relatively junior lawyers, to get involved at a really deep and important level in the development of our arguments for that case.
And we hope to show you over the course of this that most appellate cases of any significance involve extensive collaboration and the involvement of many individuals. And at Legal Aid, there were folks in the Appellate Project who were, focused on this particular case, but many others got involved. As I'll be talking about in a moment, Legal Aid is divided into a number of subject matter areas, and the BEMA case fell within our public benefits subject matter area. And so there were a number of public benefits attorneys who were involved. And then particularly at the phase where we were getting ready for the oral argument and doing the moot courts, there were a number of attorneys of all different seniorities and from different law firms and other organizations outside of Legal Aid, outside of Sidley, who got involved at that stage. I don't want to say it takes a village, but it takes a lot of people to make an appellate case work. And I think BEMA is a perfectly good example of that. All right, so the next slide is a little bit about the history of legal aid in particular. And I am not going to bore you with too much detail about legal aid, except to note that it has a very long history as, again, one of many organizations in the District of Columbia whose primary mission is to provide civil legal representation to people who could not otherwise afford it. And to talk about how important that mission is and all of the legal services community. And of course, particularly when we're talking about appeals. It is not impossible, but it is almost impossible for an individual who is not a lawyer, who is acting without representation, to navigate the system in front of the DC Court of Appeals in order to get a case all the way from the filing of a notice of appeal or a petition for review to a successful outcome. And that's true to varying degrees of cases in the Superior Court and cases before all the administrative agencies that we deal with. And that's why legal services exists, and that's why it's so important to vindicate people's fundamental rights. But the appellate arena is one where it is, in a certain sense, particularly important because the appellate system is even less than any other legal system in the district, sort of capable and geared towards handling people who are trying to navigate the system without an attorney. And you know, just one very simple example of that, one obvious example is that it's very difficult to write a brief and to follow the rules of everything that needs to be included in a brief for a pro se person. And another example of that is that the court very rarely will hear oral argument by a pro se person. It's something that they just aren't used to doing and tend not to do. So legal aid, if you can go to the next slide, has 4 subject matter units. Legal aid doesn't get involved in all kinds of civil cases in the District of Columbia, but our general mission is to represent individual clients who are living in poverty or below 200% of the poverty level in the District of Columbia, and who have legal problems in the areas that we address, which are housing, primarily eviction defense, which has currently in the age of COVID, it has both increased and decreased urgency. It's increased urgency because it's harder and harder to get and maintain decent housing. There's a slightly decreased urgency in the sense that there aren't ongoing evictions during this crisis, which is a really great thing. We also have a domestic violence and family unit, which does a variety of tasks in the family arena, including divorce and protective orders, but focuses on cases involving domestic violence survivors. Benefits unit, we'll talk about that a little bit more. The BEMA case we're going to talk about is a public benefits case, and that helps ensure that especially the very least well-off residents of the District of Columbia have access to the very most basic items that they need in terms of food, clothing, sometimes shelter, and health care, very importantly, especially during these times. And then the fourth and subject matter area is the consumer area. We have 2 areas that are not subject matter focused. One is the appellate unit and the other is a policy advocacy unit. And we, as the appellate unit and policy advocacy unit, support the substantive work that everyone else does. The Appellate Project was started in 2004, and it is a little bit different from most of what legal aid does and most of what most legal services organizations in DC do, because most legal services organization and most legal aid lawyers are focused, rightly so, on helping individual clients in individual legal cases and trying to provide assistance in that manner. The Appellate Project was born of the observation that we kept seeing the same problems over and over again in agencies and superior court. And some of those problems, not all of them and not even a majority of them, but some of those problems are the result of incorrect legal analyses or confusion in the legal arena that can actually be solved once and for all by a precedential published opinion from the DC Court of Appeals, which is DC's equivalent of a state Supreme Court, that resolves the legal issue. And the Appellate Project is designed largely to try to obtain those kinds of decisions and also to use the appellate process when necessary to obtain individual justice for our individual clients as well. I need to take a break and ask Kwaku to give his perspective on sort of what legal aid does from someone who is outside of our organization and you know, in the law firm world.
You know, so it's everything that Jonathan just said. In addition, it sort of creates a focal point within the legal community here in DC. You know, lawyers and firms do a lot of good work in terms of pro bono cases, can take on individual cases, often work with legal aid and other providers to identify cases that can have a serious impact. But the fact of the matter is that at Sidley Austin, we are not engaged, you know, every day of the week with the housing lawyers and the public benefits lawyers and so on at legal aid. We don't see the repetition, the issues emerging, disappearing, and so are not well equipped ourselves to identify the kinds of cases that could, through a good result at the appellate court, at the DC Court of Appeals, resolve a whole basket of cases. We're also, you know, if we grab one of those cases, there's a chance that we don't have the background necessary to see how a particular argument or a particular resolution could actually be a negative. So both in terms of, you know, having a group of dedicated lawyers who can focus on these cases, that's good for the legal community as a whole. They can help us identify cases, they can help us not screw up. And as my partner, Carter Phillips, likes to say, you know, if we would actually spend a lot of money if we, the private bar, were trying to do the work of legal aid on our own. It's much more cost effective if you're just thinking about it in dollars and cents terms, and we try not to, but that matters too, to have legal aid and have the Appellate Advocacy Project doing a lot of the work in the local courts to make sure that justice is done and that we're not sort of trying to chase the tail later down the line. So. I think I have lost Jonathan from my screen. I'm not sure if he's been lost from others. Caroline?
It does look like that Jonathan has gotten disconnected, so let's wait just a moment and see if he rejoins us.
Well, this would be a great time to take questions if anyone has any to offer up. Oh, Jonathan's back.
I am back, but I'm pausing because it would be a great time to take questions if anyone has one. All right, I'll assume you're typing out your questions as we speak, and I will fill the void a little bit. I think what Kwaku was talking about when I got kicked out here was a good segue into what we had wanted to talk about next, which is that the poverty law practiced in the District of Columbia, I would say that probably fewer than half of the cases are done by legal aid or similar legal services organizations. It is really the broader legal community that takes the laboring oar in the majority of these cases. And that happens in a variety of ways. So first of all, there's the broader legal services community beyond legal aid, which includes a number of generalist legal services organizations that are similar to legal aid. And it also includes a number of organizations that tend to be smaller and more focused on specific legal issues, whether it's immigration legal issues or employment law or the host of legal issues that people face in the District of Columbia. And it's hard, I don't want to go into too much detail, but it's hard to overestimate the burdens and the obstacles that poor people face when they have legal challenges, because it's not just the fact that it's virtually impossible for anyone without a lawyer to navigate these systems, and particularly the complex systems in public benefits that they need so much that are so convoluted and bureaucratic. But low-income people also have generally more barriers in their daily lives in terms of just issues with childcare, issues with jobs, issues with transportation, issues of caring for relatives, and all of the many things that just make it difficult and almost impossible for them to navigate things without a lawyer. We have in DC this very robust legal services organization community, but most of the work, nonetheless, is done by lawyers at law firms, lawyers who work for the government, lawyers who work for-profit corporations or non-profit corporations, and who volunteer their time and take a case pro bono, usually under the mentorship of someone who is in the legal services community. And I
Sorry, we're having some trouble with the IT here, folks. But I think you follow the point Jonathan was making, which is that a lot of lawyers at a lot of law firms around the city are working with legal aid and other organizations to make sure that a lot of people in need with serious cases facing serious situations of eviction or access to public benefits or domestic violence do get the representation that they need. And I think the point he was making about the mentorship and the partnership with legal aid lawyers is really important. As I was saying, it can be, these are very complex systems. Essentially, almost all of these cases arise in what are more or less administrative law settings. And, I do a lot of administrative law work in the federal courts. The parallel processes in the District of Columbia are also complex. There are practices that are unique to the courts, just in the way that the courts and the agencies handle them, and is extremely helpful for those of us who don't practice in those courts and those agencies every single day to have the assistance of legal aid lawyers who do practice in those courts every single day. So we can sort of provide the additional labor, the additional resources, the skills that we have and develop in our own practices, but also combine them, importantly, with legal aid lawyers who have the experience and also, a really unique set of skills and experiences in front of the agencies, in front of the DC judges to help guide and steer the private sector lawyers when we come in to do work on behalf of impoverished residents of DC. And that's a really important collaboration, and one that's been up and running for a very long time.
And so that's how most legal services, sort of poverty law pro bono cases, in my experience in the District of Columbia, work. A pro bono lawyer will almost always have some connection to a legal services lawyer or a legal services organization to have the kind of support that they need in order to do a case that is often slightly outside of their normal type of case. And I want to turn now to talking about how it works with appellate cases, which is a little bit different, unless, Quaker, you want to jump in with something else.
No, next slide.
All right. So, so appellate law is a little bit different. And in the past, Kwaku knows more about this than I do, but it seems like in the past 20 years or so, the bar has really begun a specialty in appellate law that didn't exist to as great an extent before then. And appellate cases aren't always treated exactly the same as other cases. Historically, in the legal services community, there has not been an appellate specialization, and most of the time, lawyers who handled a case at the administrative or trial court level will handle it at the appellate level, and that is still true today. But part of the purpose of the Appellate Project at Legal Aid was to try to create a space where there was someone whose job full-time and 100% was to focus on appellate issues and to really be an appellate procedural specialist. So the way it works at Legal Aid is that I am that appellate procedural specialist, and I rely extremely heavily on folks at Legal Aid in one of the subject matter units to provide the subject matter expertise. So when we handle a housing appeal, I'm the person who knows sort of the nuts and bolts of how you litigate an appeal, how it goes through the process, which is something we'll talk about in a minute. And I collaborate with one or more of our attorneys in, say, the housing unit who've been practicing in this area for 5 or 10 years. They know all of the applicable statutes and regulations and the agency and their practices inside out. And when you have an appellate case, it's really important to have both of those things. And it's hard to get those in one person. And so our goal is to have it in multiple people. And it's a very expensive luxury for a legal services organization to have a dedicated appellate person. So there aren't very many of those kinds of positions around. And so another thing that is part of my job description is to be the appellate procedural specialist for the entire DC legal services community. And anyone who has a question about appellate procedure or wants us to take a case over at the appellate stage, or just has questions about whether they should appeal or not. The Appellate Project tries, and I think largely successfully, to serve as a hub for that kind of coordination. Because there's nothing magic about doing an appeal. Any lawyer can definitely do an appeal, but it is good to have a specialist, and it's really a procedural specialist to help guide folks, especially through the DC Court of Appeals, which is where most of our local cases end up, but a lot of our pro bono practitioners don't practice regularly before that particular court. And so we provide that sort of procedural expertise to lawyers within legal aid, to lawyers in the greater legal services community, and also to law firm and other lawyers out there in the broader community who are doing cases pro bono.
Jonathan, we have a great question in the chat about the Appellate Project. Kenise asks, I'll be matriculating to Georgetown University Law Center in the fall and would like to know how, if in any way, one else can get involved with the Appellate Project during the spring semester or next summer.
So we have sometimes, but not always, we have interns during the school year. These are law students who agree to spend, I believe it's 15 hours a week. They generally get course credit for it. It's a whole formalized process. And that provides the project with incredible assistance in doing legal research and special projects, and also gives the interns experience not only doing that research, but doing specific discrete writing assignments to help them, give them a bit of a real world sort of writing experience. I should add that currently the bulk of the work of the project is done by a fellow. And this is a one-year fellowship that is super generously funded by Kwaku's firm, by Sidley Austin. And it's generally someone who is just coming off of a judicial clerkship and spends a year at legal aid and does really the bulk of the work of the Appellate Project. The fellow can be, isn't always, but can be someone who is intending to start their career at Sidley and essentially takes their first year that would be their first year as an associate at Sidley, and instead spends their first year here as the appellate fellow, and then goes on to Sidley and continues their associate path that way.
And that's a a contribution to legal aid that we're extremely proud of over here at Sidley. We recognize as one of the firms that sort of started the move into developing appellate practices as a specialty, the importance of the kind of work that Jonathan does, not only for legal aid's clients but for the poverty law practitioners in the district as a whole, and giving him some assistance, a force multiplier, we think is a really important and cost-effective way for us to help legal aid. And it's also a place that gives us opportunities to collaborate, as we'll talk about later. But everything that Jonathan said about how he works with the subject matter experts at legal aid mirrors what I do as an appellate specialist at Sidley. Bring procedural expertise, but not necessarily the substantive expertise in environmental or energy or food and drug regulation that our colleagues bring. And we try to fuse those areas of expertise. And I guess I would describe the appellate expertise just slightly differently than Jonathan, or I would add one piece onto it. So one is the procedural. How do you go about filing and preparing your appeal, and the different steps along the way. But the other, I think, is, which goes along with procedural, but I think of as slightly different, is what do appellate judges care about? And frequently appellate judges care about different sets of questions and different framings of questions than trial judges do, or agency lawyers do, and helping to bring out and emphasize and frame and think about how to resolve those kinds of questions in ways that are familiar to, comfortable to appellate judges is something that we try to emphasize in our own practice. And I know it's something that Jonathan thinks about a lot too.
And I want to talk for a minute about the reasons that people do pro bono work and do pro bono appellate work in particular. And I've been talking about all of the very important and altruistic reasons, which is that our neighbors in the District of Columbia have extreme need, and we do legal services and pro bono work because it's the right thing to do to help them, and because it's really the only way that they have any hope of equal access to justice. But there is also a more self-interested reason that I do want to mention, and it comes into reasons why people, incredibly talented people, will take this fellowship, and also in part the reasons why some people choose to do appellate pro bono work is that it often gives folks the opportunity to work at a higher level of responsibility early on in their careers than they might otherwise be able to for a paying client. And what that means is someone like the appellate fellow at Legal Aid, who is a very junior attorney, has the opportunity to draft an entire appellate brief and possibly do an oral argument before DC's highest court. And that is also true of law firm associates who do appellate pro bono, and other attorneys, particularly junior attorneys. Pro bono in general, and this includes appellate pro bono, is really a great way of getting experience that is often of a different kind and at a different level, and with, I think, higher responsibility than the kind of work that you might normally get as a first or second year attorney, whether it's at a law firm or the government or a corporation. It is, in my view, and I'm interested in Kwaku's take on this, sort of an excellent way to supplement the experience that you otherwise get as a young attorney.
Yeah, I absolutely agree with that. And we have our associates take and argue cases in the DC Circuit as well as the DC Court of Appeals, the Fourth Circuit, other courts of appeals around the country for exactly this reason. Clients are willing and courts are willing. In particular, the DC Circuit asks us to take on cases on a pro bono basis, and welcomes and expects that we'll give those opportunities to argue to our associates. So there are some non-altruistic reasons to be really involved in appellate work at a law firm, as well as all the altruistic reasons that Jonathan mentioned.
One thing I wanted to mention also, I'm now often asked the question, where do our cases come from? In particular, where do our appellate cases come from? And surprisingly to many people, fewer than half of legal aid's appellate cases come from cases that legal aid handled itself in-house at either the administrative or trial court levels. And the rest of the cases, about another 40%, come from our reviewing the dockets of cases that have already been filed by people pro se in the Court of Appeals. And we go through those cases and find the ones that present important poverty law issues. We call up the pro se litigants and say, hey, are you interested in having legal aid represent you for free? I used to be able to say that they always say yes. Someone recently said no, but they almost always say yes. And we litigate a lot of really important cases that we find that way. And then the other cases come, as Kwaku mentioned, from referrals from the court itself or referrals from other legal services organizations. I'm going to quickly go through the next slide, which has to do with the stages of appellate litigation and representation. You guys probably already know pretty much all of this stuff. The main point that I want to make is that there is space here for contributions by many, many different people at many different stages, different kinds of lawyers, lawyers with different expertise, different constraints on their time, different kinds of practices. A lawyer who might be, you might have a great negotiator who's the lawyer you want in the mediation, but not a good writer, so you get someone else to take the lead in briefing. And this is one of the places where law firms are particularly fabulous because they tend to have people who have strengths in each area, and they can put together teams that can really be strong at every aspect of this whole different depending on where the case is at any given time, and make sure that a client is really getting the best possible representation at each stage.
One place where we at Sibley really enjoy working with legal aid and other organizations is and preparing for oral argument, moot courts. We will frequently have lawyers from other organizations in our moot courtroom, and we'll have experienced appellate lawyers, people who are familiar with the subject matter, people who just have an interest in devoting their time and contributing the thoughts that they have to sort of act like judges for someone who's preparing to do an argument in the coming days or weeks. It gives them a chance to practice, get different reactions. I think every appellate lawyer has the experience of finishing a brief and thinking it's about one issue and then picking it up to prepare and then seeing another issue jump out and then doing a moot and having other people see other issues is the most important. And then hopefully some combination of that, of those stages of preparation prepares you for everything that the judges care about, but sometimes that's not the case either. So everyone sees the puzzle a little bit differently, and those moot courts are a really important way to prepare to see all the different angles, and that's one place where we try to come in and help legal aid lawyers as well as others.
we get more requests from people to participate by being moot court judges than I think anything else, because it's a nice self-contained thing that someone can do in 5 to 10 hours of total work, maybe a little bit more if there's extensive briefing over the course of a 2-week period, and people find it interesting to read the briefs and then play judge at a moot court. But I have to echo what Kwaku said, that in my opinion, it is the most important thing. And when you are with a group that has been working on a case for months and has gotten down into the weeds of it, you often lose sight of things that sometimes are very obvious. And people from outside who haven't had that experience of getting into the weeds and who just read your brief and say, hey, is that statute constitutional? And no one ever thought of that before. And so it's a really essential function, and something that in our experience, attorneys have really enjoyed doing as well. And Sidley in particular has provided many of our moot court judges, but we also do try to get a really diverse panel when we do a moot court, different firms, different backgrounds, different expertise, because when we have a housing case, it's going to be before a panel of judges that are none of whom are housing experts. And we don't want a panel of moot judges who are housing experts either. We want generalists just like the judges we're actually going to face, so that we get as authentic an experience as possible. So I want to pause for a moment and again encourage folks to ask questions before we sort of head into the last part of our discussion, which is just to give you some background and some description of one of these cases, a case in which Legal Aid and Sidley collaborated. The case has been argued but not decided, and it involves some narrow issues and some very broad issues about how folks in the district should be treated when they're trying to get these really basic, what we call safety net public benefits. So if we don't have any questions, do you want to start us out, Kwaku?
Sure. So our client is Judy Bima, and without getting too deep into the details, she was receiving assistance with buying food stamps, and the amount of money that you are entitled to get under that program depends on how much money you have coming into your household. So your means affect your eligibility to be receiving food stamps at all. And then also the level, if you're eligible, not everyone gets the same amount. Again, it depends on how much income you have coming in from other sources. And there is a DC statute that regulates a particular area of this program. And that is, well, what happens if you don't get actually the right level of benefits? You're eligible, but there's a glitch somewhere in the system, and so you don't get what you're entitled to, or you get less than what you're entitled to for a particular period. And in sum and substance, that statute says, well, within a 1-year look-back period, if you got less than what you were entitled to, taking into account the actual facts of your household income and other aspects of eligibility, then for up to a 1-year look-back, you'll get basically gross back up to the amount that you should have gotten the first time around. So that basically describes Ms. Bima's case. Her household had less than the amount of income than was being used, than the number that was being used to calculate her benefits over a period. And so when it finally got resolved and that got straightened out, we of Legal Aid on behalf of Ms. Bima said, well, she needs to get the full look back period. It wasn't quite a year in this case, but for purposes of simplicity, she's entitled to up to a year of whatever she didn't get, and that came to an amount. And the district pushed back, and it resulted in a dispute. And what the administrative hearing officer said was she's not entitled to that full amount because it wasn't in the district's fault. There were inaccuracies, misstatements in what Ms. Bima told them when, again, don't need to get too deep into the weeds, but if essentially the judge read the law to require a showing of fault by DC rather than just a showing that she got less than what she was entitled to. And as part of that, the district made an argument that was very surprising to me then, and still surprising to me, that the district statute governing that look-back period was preempted by federal law. There are federal regulations that govern the distribution of funds under the federal food stamp program. There are also district-level statutes and regulations. And the argument was, well, then it has to be the federal statutes that can control. They should be read to say it's a question of fault. So we then took the appeal, arguing in substance, one, there's really actually no difference between the federal regulations and the district regulations, but the district regulations are actually quite clear. The district statute says it's not a question of fault, it's a question of did you get enough? And there's no reason to think about the federal regulations as preempting or displacing the very clear statement by the DC Council that the 1 year, will make good to you for the one year period if you didn't get what you were entitled to. So, Jonathan, I don't know if you want to add to or clarify any aspects of that description.
Yeah, no, that was a great description. I think that one of the interesting things about this case is that, one of the interesting things is that the oral argument was at UDC Law School, which was a little unusual, and it was filmed. So if you guys, any of you is interested, you can go online and actually watch it. And at the beginning of the argument, the chief judge who was presiding actually very kindly gave sort of a shout out to both Legal Aid and Sidley for doing this case. And I think that shows that the court views pro bono attorneys as correctly, as providing them a service, because we hopefully make clearer arguments than pro se individuals trying to navigate the system on their own. And I think the court genuinely appreciates that. But I think the other thing that's interesting about this case is one way of looking at it is that it's a very deep dive into this statutory and regulatory scheme and trying to resolve this question, a textual analysis as to whether or not there needs to be fault by the district in order for the 12-month look back to apply or not. But the questions that the judges asked really also highlight a different way of looking at the case, which is a much more big picture way of looking at the case, which is, as a society, do we view a program like food stamps as something that's really technical, where the question is, did you jump through all of the hoops? And if you jump through all of the hoops, then you get the money. And if you don't jump through all the hoops exactly correctly, you don't get the money. Or do we view it from a much more pragmatic point of view as saying, the question is, did you need money for food? And that's basically a question of what's your income and how big is your household? And you should get the money that's based on your income and your household size. And we should get the right answer. And if we don't get the right answer until a few months later, then we should go back and fix it. Why? Because it's the right thing to do. Because giving people the amount of money that's based on their income and their household size is what the purpose of the statute is, not setting up these barriers and asking these questions about whether people filled out the paperwork 5 days late or whatever. And in fact, one of the more interesting aspects about this case is that there's a regulation that required the agency to help Ms. Bima, to help the food stamp applicant establish their eligibility. And the agency didn't do that for 10 months. And that's what caused this whole problem to begin with. And so another way of looking at this case is to talk about the government's role. Is the government's role simply a gatekeeper where the government holds with a tight fist onto its money and makes sure that every single box is checked before the money is handed out? Or is the government's role to say, do you fit within the gist of this law, and can we help you check all of the boxes you need to check in order to get this money? And you know, in general, our DC Court of Appeals is really excellent on these kinds of issues and is focused on the big picture of these kinds of cases. And this case, to me, is interesting but not unusual in that it presents this very narrow question of here are some statutes and regulations and how should we interpret them, but also this broader picture that is the kind of thing that we are working on and hope to get nice statements from the Court of Appeals on the general rules that when you're looking at a program like food stamps, you interpret it in order to get this needed financial assistance to people so that they can have food on their tables. And that's the way you should look at all of these basic safety net programs. And you should not look at this as a trap for unwary people and unsophisticated people who might not be able to do everything exactly the way the agency wants them to do it, but who unquestionably are at the end of the day entitled to these benefits because they have a very low income and a certain number of mouths to feed, and that's what food stamps is all about.
Just to add on to that a little bit, or maybe just to pull the telescope back a tiny bit. I mean, I think this is one of the things that I hope you're seeing, whether, for those of you who are about to start law school or are working your way through law school, and those of you early in your career, is just how complex, truly complex, the statutory and regulatory schemes are around the poverty law, and then immigration is another area. There are a lot of these, regulatory schemes basically that are about as complex as an area of law as any you could encounter anywhere in the practice of law. And yet we generally expect people to navigate them themselves. You don't have a right to counsel for essentially any of these programs. And many of them, it will be held against you if you mess something up, either before you get into court or while you're there. And so I really think it's an amazing opportunity for you as a practicing lawyer to get involved, because you can, whether for individual cases or more systemically, you can really help. You can, yes, these judges were asking questions that showed that they understand that it matters how these programs are structured, but they're also asking the kinds of technical questions that demonstrate their correct understanding that it's not just up to them to decide how these programs are structured. They're coming to an area of the law that has some lines down already, and so they're trying to navigate both of those things. Can we make this work in a practical way for everyone? And also, what's our role as judges, given statutes and regulations and precedents that mark certain places where we're not just free to make a decision. And so being able to bring your technical skill, but also your passion and your sense of citizenship to the table, whether as a full-time poverty lawyer or as I am as a part-time poverty lawyer, I think is incredibly rewarding.
Thank you, Kwaku. I'll just echo that. I hope that part of the reason you're listening to this webcast is because you are interested in helping people facing the impacts of poverty in DC. And there are many ways of doing that. And I hope that you will choose one of them and follow it up, and that it will be a rewarding experience for you. My observation, of course, personally, but also for the many other pro bono attorneys that I've worked with and collaborated with and observed, is that it is often among the most professionally and personally rewarding experiences that people have as lawyers. And I encourage all of you, especially those of you who are early in your careers, to try to get involved. So we have managed to chew up an entire hour. Caroline, do we have any questions that we should be addressing before we adjourn?
We do not have any questions at this moment. I encourage anyone who has it to shoot it in the chat as quickly as you can, because we do have to wrap up. So unless we get any other questions, just thank you so much, Jonathan and Kwaku, and thank you everyone for joining us. We do not have a session next week, but in 2 weeks, we'll be back for a 4th session on the eviction crisis.
And I encourage you to also, if you do want to contact us, I should have had a contact information slide, but Legal Aid actually has an excellent website that includes contact information and a host of other information. It's legalaidDC.org. There you go. Thank you, Caroline. There's a ton of information. A lot of questions can be answered there, and also contact information for me. You should feel free to call or email me, or frankly, anyone else at Legal Aid with questions that you have. And I want to thank you, Caroline, and thank you, Kwaku, for putting this together and making this happen. And I know both of you are extremely busy right now, and I appreciate your taking the time.
It was my pleasure. Thanks, everyone, for taking the time.
Enjoy the rest of your day, everyone.